subsection 61 of the criminal conspiracy under Bharatiya NYAYA, what does it say? It says, when two or more persons agree with the common object to do or cause to be done, an illegal act, etc., etc. The earlier definition was when two or more persons agree to do or cause to be done, so and so, so and so. The complete absence of what is called a common object. And there is one subsection which also says, or the explanation to the section, which says, it is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. So therefore, by definition, by logic, we had accepted the notion that the first set of accused who just got the contraband from a launch and took it to the shore may not be aware of the ultimate object. It is immaterial what is your ultimate object. You are still liable. Now the moment you say it is immaterial what is your ultimate object, where is the idea of common object? That is why, as a student of law, perhaps according to me, these are inconsistent ideas. And this is going to lead to a tremendous amount of debate, discussion at the bar. And this will lead to elements of uncertainty and a principal provision with which we can fasten the liability on conspirators will get diluted. So the rigor or the severity of this punishment, of the provision of conspiracy, we may find coming under the question mark. And that's only with this introduction of common object. If your idea is to have the very same logic of common object under unlawful assembly, that is to say, presence at every juncture, then it's fine. Then this provision is not going to serve the purpose. So this is why, on certain scores, as my previous speakers were at pains to say, that perhaps the time was right to have a rethinking in the matter. Yes, we have done that. But at the same time, I don't know whether it is the error committed by the draftsman or is it something which is with clear design. The earlier 120B never had this element of what is called common object. And therefore, you are now creating a hybrid idea in the theory or genus of conspiracy. So therefore, perhaps I think, we as persons who will be definitely concerned with the administration of justice, those who are in the executive police department, those who are prosecutors, those who are judges, need to now concentrate more on provisions such as this. Very well, this was one. Now, there are certain provisions where perhaps I think the punishment has been enhanced. With the passage of time, we have learned from our experiences. Now take for instance, culpable homicide not amounting to murder as a result of rash and negligent act. That rash and negligent act may be because of your reckless driving, maybe because of negligence on part of medical professional, maybe because of negligence on part of somebody who is supposed to be a caregiver. Under the old 304 Part A or 304 capital A, the maximum sentence used to be for 2 years. And therefore we had so many such cases where the vehicles have run over the people, where the vehicles have rammed into some of the jhuggi jhopdis, so therefore killing people. And yet, what is the ultimate sentence? 2 years. The travesty of justice was that even in Bhopal gas leak disaster case, the sentence which was given was 2 years. Why? Because the finding was rendered it was a negligent act. And that's where what perhaps I think rethinking was definitely required, definitely necessary. And today the provision, which is the parallel provision to that, which is perhaps section 57 of Bharatiya NYAYA SANHITHA, now speaks in 3 different tones. Number 1, if as a result of any rash and negligent act, a death occurs, then it would be 5 years, not 2. So it may extend to 5 years. Secondly, as a subset of that, if the vehicle as a result of which the death is caused, or the person who is responsible for causing that death by a rash and negligent act vanishes from the scene, there have been hit and run cases that we see so many times. People after the accident don't even wait for that, don't even try to give first aid or some sense of comfort to the person who has been the victim of that. Then if such conduct is exhibited by the person who is guilty of the offense, then the sentence can be 10 years. So therefore now 2 years at an advanced level of 5 years, and if there be such illustrious conduct, then 10 years. But at the same time, the legislature is careful to say that if as a result of some medical negligence, something happens and the life is lost, it will still be only 2 years. So what was originally 304A, which carried sentence of 2 years, now you have 3 levels of different ideas which are emerging from the parallel provision. So 5 years, aggravated form 10 years, and for medical professionals, again only 2 years. Which is such a welcome provision. Because then you were bundling everybody in one single basket, that is rash and negligent act. What kind of act? Rash and negligent act. What kind of, under what circumstances? If suppose somebody is actually under the influence of alcohol. That is precisely why some of the High Court decisions went to the extent of saying that if you are under the influence of alcohol, then not under 304A but 304 Part 4. God knows, yes, that's why, because as a judge perhaps I think you feel compelled that your sense of justice doesn't sort of get satisfied that for the loss of life, where that case which was Alistair Pereira, 7 persons of a family lost their lives. Why? A car will run over them. So therefore your sense of justice doesn't accept that, and therefore you try to put it under some different slot. Not necessary anymore. You still have something which is an adequate punishment provision which is guaranteed. So therefore that's number 2. I have such 6 or 7 instances. This is only to sort of brush up our ideas. Then the third one, there is a particular section sorry, that section was not 57, it is 106 in the present code. Section 57 is abatement by public or more than 10 persons. It's a very specialized provision where, supposing if abatement is done by 10 or more persons or by public, the wrath of public, the anger of public, and public is actually responsible. So under the old law, it used to be only 3 years. Today you have extended it to 7 years, made more comprehensive, more sort of, worthy of some kind of substantive idea. So therefore that was the third provision which I wanted to place it for the consideration of this gathering. So therefore 3 ideas which emerge out of that. Now the fourth one, and that is to say, when it comes to rape on a minor girl, the present code has made distinctions at 2 places. If the girl happens to be less than 16 years, then the punishment can be aggravated punishment. If the girl happens to be less than 12 years, again an aggravated form of punishment. But unfortunately, the quantum of punishment in both cases is identical. So then, what is the distinction here? You could simply have said girls under 16 and everything would be covered. You don't have to make a further distinction, girls under 12. Either if there is supposed to be a different idea or a filter to be adopted, there is no such filter which is indicated in the statutory provision. So therefore, again, I don't see any reason why there could be internal distinction of a category or a cadre such as this, below 12, below 16. If you happen to be giving the same punishment, which is to say 20 years in both cases, it hardly makes any difference. Unless you were to say that very well the norms of punishment will be slightly stricter or harsher or harder. Then one more criticism which is some of the social thinkers and legal scholars at one stage, if you recollect after this NYAYA case in Delhi, there was a committee which was headed by Justice J.S. Verma, of which Justice Gopal Subramanian was also a member. That committee went into certain issues and suggested some of the modifications to the Indian Penal Code. And one of their suggestions was that make rape an offence which is gender neutral. So not necessarily minor girls, even minor boys can also be subjected to a very very dark kind of offence, which may leave a great imprint on their persona and which will damage their entire personality all through the life. And so therefore, let the rape as an offence be gender neutral. But unfortunately, that was not accepted as in the Indian Penal Code stood before this NYAYA came in. And again, the same definition has been borrowed here. So therefore, the rape has to be only upon a female child or a female or a lady or a woman. So the gender neutrality principle perhaps has not been accepted by the legislature when it comes to offence of rape. Now imagine you have expanded the scope of definition to say insertion of any kind. Why doesn't it apply to minor boys? It can also have a disastrous effect on them. So therefore, that's one area perhaps I think the legislature should have given a good thought, or at least made a comparable or parallel provision where perhaps with lesser, stricter ideas you could still have with contingencies or situations such as that. So that's my third idea which I am presenting before you.